YouTube, it's Tone. Back with another one for you. This one is a continuation of the court survival. This is the 9th video. I think there might be 1 or 2 more videos left in this here, and we'll move to something else. So let's get into this. This is getting more into toward the end. You already passed litigation. You couldn't work out a deal. You already went through trial. Your jury selection. The judge is still not hearing it. Still trying to play games. And then here we are. So now you're in the middle of giving the instructions to the jury here, instead of letting the judge tell them what's going on. And you're introducing a lot of information for them to understand who it is that they are and what the job really is here. So, ladies and gentlemen of the jury, you are instructed that from Chicago Motor Coach versus Chicago, the use of the highways for the purpose of travel and transportation is not a mere privilege, but a common and fundamental right of which the public and individuals cannot be rightfully deprived. So, this is pretty much saying that these people are not God and they have no authority to tell you when and where and how you can't go or can go or anything of that nature. It's not within their. It's not even within their scope of delegated authority, to be honest with you. They only have the authority to regulate commerce. So if you're not literally engaged in the act of commerce at any point, they have no jurisdiction over you. It's really that simple. You can try to confuse it or throw some bullshit in there, but that's really what it comes down to, fundamentally. So 22, ladies and gentlemen of the jury, you are instructed that from, this is citing a case, Sherrod versus Cullen, for a crime to exist, there must be an injured party. They call it a corpus delicti. That's an injured party. In common law, there has to be an injury of some sort. So there can be no sanction or penalty imposed on one because of his exercise of constitutional rights. Your constitutional rights can never be converted into a crime, but they'll try. They'll turn it into a tax and call it a crime, but really it's civil in nature. So ladies and gentlemen of the jury, you are instructed that from Kent versus Duels, the right to travel is part of the liberty of which a citizen cannot be deprived without due process under the law of the Fifth Amendment. So 24, ladies and gentlemen of the jury, you are instructed that from Miranda versus Arizona, where rights secured by the Constitution are involved, there can be no rulemaking or legislation which would abrogate them. Ladies and gentlemen of the jury, you are instructed that from Miller versus U.S., the claim and exercise of a constitutional right cannot be converted into a crime, and that's a fact. And that's going to be a fact. So, ladies and gentlemen of the jury, you are instructed that Mugler versus Kansas, under our system of government, upon the individuality and intelligence of the citizen, the state does not claim control over him or her except as his or her conduct to others, leaving him or her the sole judge as to all that affects him or herself. So as long as you're not interfering with anybody else's movie, then you're good, right? It's supposed to be that way. So governments derive their just powers from the consent of the governed. Ladies and gentlemen of the jury, you are instructed that from Thompson versus Smith, the right of a citizen to travel upon the public highway and to transport his or her property thereon, either by carriage or automobile, is not a mere privilege, which a city may prohibit or permit at will, but a common right, which he or she has under the right to life, liberty, and the pursuit of happiness. Now, this shit here is all common law because what you're doing is using case law, essentially, to state your case. And judges usually side with whatever the rulings were in the higher courts and shit like that. They're actually supposed to, but they don't always. So this would be common law. Right here is basically case law. So the prosecutor will submit some instructions, and you will submit some, and they will try to discredit and dismiss yours in favor of the prosecutors. When they try to dismiss each one of yours, demand to hear specific legal justification for doing so. Don't let them get away with any vague or generic excuses. If there is nothing particularly wrong with an instruction, the jury must be allowed to read it. If the judge tries to dismiss an instruction because of not being relevant, the motion for a finding of fact to determine the definition of relevant and whether the instruction is relevant to your case. Make them work for their corruption. All right, pull out the books. Pull out the books. I don't think they get so confident when they have to pull them books out. You never even see them shits open in the freaking district courts. They're out there with a freaking magazine on their desk and shit. So, if you have an objection to what they are trying to pull off, you must object to each instruction separately. And you must present specific argument and or evidence that proves specific violation of law. Here are some more backup quotations that you may use for evidence and or instructions. Thomas Jefferson, I consider trial by jury as the only anchor yet imagined by man by which a government can be held to the principles of its constitution. John Adams, it is not only the juror's right, but the duty to find the verdict according to his or her own best understanding, judgment, and conscience, though even in direct opposition to the direction of the court. John Jay, first Chief Justice of U.S. Supreme Court, 1789. The jury has a right to judge both the law as well as the fact in controversy. U.S. versus Daugherty. So the jury has an unreviewable power to acquit in disregard of the injunction of the law given by the trial judge. So you want to go with what you know to be right and what you know to be fair, as if life is fair, right? But that's what this is saying. So we recognize the undisputed power of the jury to acquit, even if its verdict is contrary to the law as given by the judge and contrary to the evidence. If the jury feels that the law under which the accused is unjust, or that the exigent circumstances justify the action of the accused, or for any reason which appeals to their logic or passion, the jury has the power to acquit, and the lower courts must abide by that decision. State of Georgia versus Brailsford. The jury has the right to take it upon themselves to judge both the law and the facts of the case, as well as any fact in controversy. Abraham Lincoln says this, supposedly, right? The people are the masters of both Congress and the courts, not to overthrow the Constitution, but to overthrow the men who pervert it. And that's really what it comes down to. That's really what it all comes down to. People try to act like somebody's attacking the Constitution or the laws and the bullshit like that, but that's not what it is. It's literally the people that are abusing it. It's not the law in and of itself, because that shit is not corrupt, but the people are corrupting it. The men are corrupting it. Strategy 7, opening statement plan. Okay, somehow you're still on for trial, and you are not going to make your opening statement. This strategy is just a way to expose the prosecutor's strategy, negatively planted in the minds of the jury or the judge. You can easily use this if you can present evidence or testimony that contradicts or exposes the fraud in the prosecutor's case against you. So with the format given at the beginning of this section, you can add something like, you will see people that the prosecutor's argument and accusations are stuck in an unfair system of contradictions. You will see that all he or she can do is kind of rewind and play back. Well, you didn't hear this or that, and say that and says here that this is a crime, etc., without also showing you the other evidence of laws that apply, and without asking you to even think about the contradictions. However, that because of these contradictions and evidence that the prosecutor does not want you to see, you will see from my defense, statutes and stands accused cannot possibly apply to this case, and I want you to remember this point. No statute can lawfully be enforced where it does not apply. And that shit is huge, because you got to understand that these people are trying to apply civil maritime admiralty jurisdiction on you when you were not operating in commerce. That shit doesn't apply. It doesn't apply. So unless you challenge that, then it's going to, because you're going to assume it does, and they're going to play along. So keep it simple and to the point, but be empathetic. Remember to include in your opening statement a strong reminder that you are not obliged to prove innocence. It is instead the prosecutor's responsibility to prove guilt. All you are obliged to do is to show reasonable doubt as to the validity of the prosecutor's accusations. Strategy 8, demand the evidence. When it is your turn to introduce evidence and testimony, this is where you are bluffing the court into exposing their fraudulent jurisdiction over you. It is your driver's license and application, i.e. government contract, which binds you to the traffic statutes. So given that you haven't yet rescinded your contract, and even though I did before too, mind you, this is a side note, so I even fucking rescinded it, sent it back, with all that with affidavits, and they pretend not to get the shit, right? So then they'll try and charge you with driving without a license after and all that, even after you give it back. So you can't even count on these people to actually do their damn job. So you got to keep all your proof on you. Keep good records, because that is court. All right, the mail is court. So mail everything certified, registered. Keep really good records, because these people don't play fair. That's just what it is. So given that you haven't yet rescinded your contract, then this is what's really holding you liable for complying with the statutes. Of course, they don't want you to reveal that to anyone. So here you must simply declare that the court has yet to prove its jurisdiction over you under the insidious 14th Amendment and demand that the court place in evidence the contract that they must be using to enforce the laws against you without your consent or knowledge. Do this especially if you have reserved this right explicitly at the beginning of the hearing. When the judge refuses, then motion to dismiss for failure to make evidence to establish jurisdiction. If they refuse to budge, object, ask the judge if he or she has made a judicial determination that violates your reserved right to introduce evidence relating to your case. Strategy 9. Admission of truth by testimony. This is perhaps the best way to educate and inform the jury, as well as getting evidence against the judge and prosecutor on the record. So here you're going to call some of your friends, perhaps even some of your legal counselors, to stand for the sole purpose of spilling the beans with their testimony. So you bring people in there, right? Put them on the stand, and then so you're controlling the show at this point, right? And so this is what they do too. And then so they're gonna ask you or you ask them the right questions in order to get out what it is that you're trying to get out to the jury, and you really can't get in trouble for it because you're not the one saying it. And even if the judge strikes the shit, they already heard the shit. And these are the stupid ass games that they play too. So you play stupid games, you win stupid prizes. You know what I mean? When in Rome, do as the Romans, bro. So all you have to do is work out ahead of time with with each of your witnesses the plan and question of answers, and that's all it is. So you're going to ask the questions relating to your case, your actions, the statutes, the officer's actions, how they feel about the law, what they would do if they were the judge or the jury, if necessary. You may even ask them about their court procedure itself and as it's going down, how they feel about the actual case that they're sitting on. So you can bet your life that the prosecutor has already made such arrangements with the officer, and that's exactly what they do. So here's your chance to even the score. The main purpose is to admit that all evidence which supports your defense, your arguments, including law, educates the jury of their rights and corners the judge into a fraudulent legal determination. If they try to silence your witness, you can object, tell them that they are out of order. The witness has the right to say whatever they want, and they are sworn to tell the truth, the whole truth, and nothing but the truth, not just what the court wants to hear. So they are faithfully answering the questions put to them, and testimony cannot be denied. Your witness can even be reprimanded. Your witness can even reprimand the judge. Your Honor, I have sworn to tell the truth, the whole truth, and nothing but the truth. And unless you can legally defraud me and this court out of my oath of truth, then this is exactly what I intend to do. Pretty much telling them that you agree to tell the truth, the whole truth, and nothing but the truth, and you're going to do that. And if he wants to stand in the way, then it's a mistrial at that. What are you doing? Obstructing justice and shit. You know what I mean? So instruct your witness to verbally defend themselves against any insult, offensive remark, insinuation, or intimidation by the prosecutor or judge. Strategy 10. Play legal counsel. During the testimony, this is you conducting your brilliant defense as planned and described in the motion strategies in the previous section. So to outmaneuver and back the judge into an embarrassing position of having to make a determination, use any of the still available strategies to keep the prosecutor on a short leash. You are not going to let anything get by you this time. Your tools and your intelligence, your self-esteem, the truth, your evidence, your witnesses, the court record, your knowledge, your strategies, and your legal counselor. So you see what type of energy really has to go into battling these fucking demons. You know what I mean? It's like definitely got to pick your battles. And better to have everything already set beforehand. Get your contracts in place beforehand. It'll save you a lot of this bullshit. Promissory Estoppel is the best way to go, to be honest with you. This is putting them on notice prior to any bullshit happening. So there's different steps to walk through for things like that. This is for people who are literally caught in the matrix trying to fight their way out of that shit. So that's where this would come in handy. For sure. And I mean, it will even. So it's not a bad thing to know. So strategy 11, halftime, motion to dismiss. This is a freebie. After the testimony, you are allowed to motion the court to dismiss the case at this time because of lack of evidence against you. Do it. Strategy 12, final statement plan. So this is your last chance to win the trial part of the game, if you are still in the game. Just as the opening statement, you are going to plant a negative perception in the prosecutor in the minds of the jury or the judge. The prosecutor gets the last word in, and you can bet that he or she will be shooting your case down. So what you'll want to do here is remind the court or the jury of exactly what you asked them to look for in your opening statement. Sum up the results of your defense as you have so brilliantly presented it. Remind them how your defense actually shows that you actually represent the people, the jury, and anyone wanting fair laws. Then remind them that the prosecutor's feeble attempt to rewind playback his or her illusions, keep it simple and empathetic. So then make a guess at which of the illusions he or she will try to shoot down in the final statement. It could go something like this. Just look at what has happened here today. Our alleged prosecuting attorney, claiming to represent you, the people of the state of XYZ, has just demonstrated his or her choice to instead harass and intimidate all of us into obeying laws which are forced upon us as slaves without our vote, without our consent, without our approval. No injured party. In fact, the only things that they have from us to force these laws is our money and our lack of resistance. Think about this. What's wrong with this picture? The prosecutor may even stoop so low as to claim that I am guilty because XYZ, or that you people are, by minding my own business, somehow injured by XYZ. Or you can possibly believe that for this illusion, then how can XYZ be true? So these are just basically, little arguments that you're going to be throwing back and forth at the end in order to, basically summarize what it is that the whole case went through and what your point was. So this is where you get your opportunity to highlight certain points and things like that. So convince them that there has been more than enough reasonable doubt presented, that the accusations are unfounded and that they have too many holes in them to prove guilt beyond reasonable doubt, and that we are innocent until proven guilty beyond doubt. So finally, make sure that each juror understands that each can vote not guilty for any valid reason that they see fit. Independent from others, the vote does not need to be unanimous. So stick to your convictions. Tell them that the only fully informed and fully responsible vote possible in the light of what we have all seen and heard is not guilty. So you're trying to just drive that home. So the final notes. Remember to use all of the general strategies at the beginning of this guide as your survival tools in order to deal with the prosecutor and judge. Review your entire courtroom plan for the day before the trial. Get plenty of sleep the night before, knowing that you are well prepared to defend your rights and expose as much of their fraud as necessary to win your case. So sleep, rest is much more valuable than staying up late cramming. Strategy 13, the sentencing. The sentencing is just a formal slapping of your hand because you have been naughty. They are teaching you a lesson that the people will soon learn about, so that everyone will abide by the rules which will enslave them. Because you have been found guilty, you must pay your debt to society, huh? That's what they say, that you must pay. Pay your debt to society. So it's all commercial. Talking about debts. So you must pay some penalty back to the corporate state. Your purpose should be to either minimize your expenses or to defer the case to retrial or appeal. What to expect? The judge will make condescending speech to make you feel guilty or responsible for what they did to you. Pay careful attention. During this hearing, the judge will politely and cleverly ask for your consent, pronounce sentence against you. Then the judge will ask you questions about how guilty you feel and how much money you have. It's true too. So they all want to know how stiff they can make the fines in order to bring more money bring more money into the cash register court. So the prosecutor will try to make the judge believe that you have been a particularly vile and contemptible criminal and ask for maximum penalty. What to do? You must decide whether to continue standing up for your rights or to bail out and cut your losses. The rationale should be based on how you feel and what you can hope to gain either way. So you must weigh your pluses against your minuses, pretty much weigh your odds. If you haven't paid them anything yet and you can tolerate the waiting period, then you might as well stand firm because many cases are won back in the appeal. So strategy 0, exercise your rights of allocution. That's basically your final formal statement too. So this will be your last chance to win without going to retrial or appeal. So you are essentially going to refuse giving your implied consent to the sentencing and then go with the flow of how the judge responds. Speak with conviction. So when the judge asks you, can you think of any reason why I should not sentence you now? Or do you have any objections to being sentenced now? You immediately say yes. This is where you can make a concise speech. Yes, Your Honor, I object to this sentencing at this time because although the facts of the case may have been decided, the real issues of law are still in question, and I give this notice to the court that that if I am sentenced at this time, I will raise my objection to the appellate court in the nature of a writ of error. The judge might try to shoot you down by saying that the writ of error has been abolished, so that you would respond, yes, I know. That is why I will raise my objection in the nature of a writ of error. This makes my objection a colorable writ acceptable to the colorable court. Then finally say, as I'm sure you're aware, that upon the acceptance of my objection, the transcript of this case shall be brought forth by this court at its own expense, and that each and every legal determination shall be reviewable by the preservation of the legal issues at hand. This should intimidate the judge into reversing the verdict and acquitting you of the case, and if only if they want to pronounce sentence, you can continue with your objection as follows if they move forward. So logically argue that what they have perpetuated upon you is not only an insult, but also a moral and civil crime against we the people, and that you could easily soon be facing charges of treason, fines, and prison. Tell them that you are aware of their controlling manipulations of the procedure to create the appearance of being above the law and under color of law. But because of the extent of their fraud and corruption, there is no way to conceal it all completely from the reasonable investigation. Then tell them that the only power that they have over you is what you have freely given them. Thank them for the education, but now you know the truth about them, and there is nothing more than you could possibly learn by the virtue of this harassing and penalizing bullshit, right? And so that's why I say too, a lot of this shit that like I went through different stages of being mad, and all the emotional processes of fucking processing all this shit. And so what I see is that, everything's just ultimately a lesson. You know what I mean? And when you learn it, then you don't have to fucking deal with it anymore. And you're gonna keep getting it in different ways until you deal with the bullshit. So I suggest that everybody studies, man. Definitely know this shit. Because they're not who they say they are. Nothing is what the fuck it seems. So it is the game of chess. Stop playing checkers with these clowns. That's what I got for you for now. Until we meet again.